in Lidl Great Britain Ltd and another, and Tesco Stores Ltd and another.
Yes, Mr. Nalnich, I can tell you that we have read the skeleton arguments, we've read the judge's judgment, we have read Kinder, Target Ventures and Skykick. Don't let me stop you from taking us to any of those authorities if there are bits that you want us to see particularly, but we've read them.
I'm grateful. I'm grateful. Please, my lords, I appear for Tesco, the appellant in this appeal, with Mr. Selmy, my learned friend, Mr. Brandreth, appears with Mr. Sherlock for Lidl. The appeal, as you've seen, is from an order of the lower court striking out or giving reverse summary judgment on the counterclaim for bad faith under Section 3.6 of the Trademarks Act. We say, in short, this was a well-founded counterclaim, and we're dealing essentially with a mark which has never been used, never been seen by public, despite being repeatedly applied for in this country over many, many years. Now sued upon against Tesco for using a device of a roundel on blue, which has different wording on it. And that tells the court something, we say, right away, which is that this is an unused mark which has been applied for the purposes of bolstering the protection in Lidl's logo as used. And that really is the case. There's more to it than that in terms of understanding the sting of the evergreening allegation and certainly a bit about the defensive marks, but my lords have indicated that they've read the Target Ventures and Kinder Surprise case. So really, that is it in a nutshell. The judge essentially held that is not a claim in bad faith. We say it clearly was.
Can you enlighten us as to the extent to which Target Ventures and Kinder were cited to the judge below? I've seen your supplementary skeleton, and correct me if I'm wrong, but the impression I have from what you say there is that Target Ventures was in the bundle, but I'm not sure if the judge was actually taken to it. And Kinder, she doesn't seem to have been referred to until the form of order hearing.
She wasn't referred to Kinder until the form of order hearing.
Right.
But that was obviously supplied by way of skeleton in advance of the form of order hearing with permission to appeal grounds. The Target Ventures case was in not only the bundle but also in the skeleton, and it was the only authority cited in the skeleton. Now, I should also add that in my oral submissions, I think we said in the transcript, we opened with the point that this is a defensive mark. The problem, as I'll come to in a moment, is when you look at these cases, none of them are ever on all fours with any other. Bad faith cases are notoriously fact sensitive. In fact, there's learning from the Court of Justice that says, well, you should be careful.
That, of course, is true, but as I understand it, your argument in a nutshell is, as you've just stated, namely that it can, whether it is will be matter for trial, but you say it can be bad faith to register a mark not with the intention of using it, but in order to obtain a wider scope of legal protection. And in support of that, you point to two cases, one domestic and one European, where that argument has, on the facts of those cases, succeeded.
Yes. In a slightly different way. They were word cases. Of course, that's a problem, it might be said. The Kinder Snappy case was stockpiling a lot of marks, which is its own vice, so to speak. And the Target Ventures case was having another mark that was a bit similar to an element of your used mark. So that comes potentially closer, but yes, that is what we say. We say that the notion of defensive marks has also been discussed in the case law, and there are a couple of other authorities in the supplemental skeleton which basically say that they're a bad thing. But beyond that, there isn't much more to it. And so far as evergreening is concerned, you will have seen from our skeleton that has an independent life, but also a related life to the defensive mark. Because if you've got a defensive mark and you're already in the strategy of running a defensive mark that's not used, you want to expand your protection, no doubt you are aware that it's potentially liable to be cancelled on grounds of non-use. So from time to time, you reapply. Now, I will take onwards to that, but obviously that itself is a vice, a separate vice. From you can have a genuine mark, a non-defensive mark, that is evergreen, and that's what happened in the monopoly case. So what I was proposing to do was to see...
Your point surely is that you don't look at these elements individually, you bundle them all together.
You bundle them all together, you must look at all the facts as a whole. They're always going to differ from a previous case. And there's a case law that I could show you that says, it's the monopoly case itself, where the General Court said, the fact that a factor is missing from a previous case in your current case, it doesn't mean there's no bad faith. And that, in a sense, is what we think the error that the judge fell into. This wasn't a unique case, as most bad faith cases will be. And it was a bit different from Kinder Snappy, and a bit different from Target, and a bit different from the other case where there'd been stockpiling, Copernicus, and so on. But it was, broadly speaking, an abuse of the register, in the sense that it fell in that category. But by the way, when I say it is, of course, what I'm saying is it's arguably to be established at trial, could be, and the facts are consistent with that. So it may be helpful to start with the basis of the application, because the case morphed to some extent, and there's been various points made about the pleadings and so on. But we say that the application, as it was put in the original application notice, was very much predicated on the idea that if they win on use, they win on bad faith. So, as a matter of fact, if the court accepts that there has been use of the mark in variant form, then they must win on bad faith, and I'll show you that. So if you take the application notice, sorry, it's in the supplemental bundle. And the application was brought a bit unusual, actually. The judge said that we weren't prejudiced by it, but that's really not the point. I think it's more a point of whether there was any basis for the application. There's a short application notice seeking strikeout, and then over the page, you can see on tab 2, page 18, the Lidl applies for an order striking out the bad faith claim, counterclaim for the reasons set out in detail in Bird and Bird's first letter. That's the next document. Leaving the first page aside, or just coming to the bottom of the first page on page 19, in all cases the allegation of bad faith is disproportionate and hopeless. We invite your client to withdraw it. Our client is of this view for two reasons, namely that the bad faith allegation is redundant. It can only potentially succeed in circumstances where the revocation for non-use has succeeded, and it's bound to fail in circumstances where the revocation for non-use would also fail. Bad in law, the facts alleged do not come close to an arguable case of the commercial dishonesty required to sustain the allegation, and these were cited by the judge. I just wanted to show, my lords, the scenarios envisaged by Lidl. If the court was of the view that there had been use of the wordless mark by the Lidl logo, then the revocation action fails. And at the same time, it is said, the allegation of bad faith, no intention to use those marks, also fails by extension. So it's a sort of ex post facto blessing of the original intentions of Lidl. It is said that Lidl had an intention to use the mark when the main mark was used, but there's no evidence of that. It's not even pleaded, and it is said here in the letter, it was also said in submissions, that was the intention, but we questioned that. we don't accept that for a moment. But then, and I'll come to what happened to that allegation, then it says, alternatively, if there's a finding that there's been no use, even though the revocation action succeeds, there would still remain an issue over invalidity, since it doesn't follow that the subjective intentions of bad faith are made out. Well, that, we say, encapsulates the contradiction in the whole application, because the claimants, Lidl themselves, are there accepting that their intentions when they applied for the mark are a separate analysis from the question of whether there has been as a matter of use, as a matter of law use. And in fact, it was scenario B that the judge proceeded on. The judge held that she should not assume that Lidl had been successful in its revocation action. In fact, that it would be better to assume that they had failed.
Lidl had been it.
So
You mean
Lidl-
Tesco?
Sorry, that Tesco had been successful in the revocation action of Lidl, right? So, what the judge held was, I'm going to assume there's been no use. The court will find no use. And even in those circumstances, the bad faith claim is not made out. But we find that hard to accept, obviously, because leaving aside the fact that intention and use are completely separate things, the fact that the court has held that there's no use would suggest that, if anything, there was no intention to use as well. But the most important take-home point from this is intention, when you apply for the marks, is completely separate from the question of legal validated use many years later as a result of the Specsavers decision or whatever it might be. If one thinks about it, it's not dissimilar to what happens in other cases where, for example, in Skykick itself, you had an application for upholstery and leather goods or whatever, and then Sky found that they started sponsoring the Sky cycling team, and they said, well, we used, and we intended to use for that. Those are two separate things. They might be able to save the use from a revocation action if they've resumed use and started to use in relation to, they've commenced use in relation to leather seats for cycling, for cycles. But they could never say that when they applied for them, they had that intention. And that's the very clear blue water between those two scenarios. So now, when it comes to that aspect, the case was put very much on that basis, as I say, and we say it simply failed on that basis. Can I then turn to the law on striking out? Obviously, that's going to be something very familiar, and I'll just spend a couple of seconds on it. The judge, it may be helpful just to look at the judgment in your core bundle, paragraphs 39 to 41. 3. And these were not in dispute, but we do say that the judge, having cited these principles, lost sight of them when it came to considering whether this was a suitable case for strikeout. So the court may strike out a statement of case if it discloses no reasonable grounds for bringing the claim. It may grant summary judgment on no real prospect. As to the applicable test, it says at the bottom of the page, the court must consider whether the claimant has a realistic as opposed to a fanciful prospect of success. That should not be carried too far. The court is determining whether the claim is bound to fail. At 41, it says, the judge said, Coulson LJ drew attention to the fact that it is not generally appropriate to strike out a claim on assumed facts in an area of developing jurisprudence. However, I did not understand Mr. Melanie to suggest that the issues arising in respect to the bad faith allegation were novel, such that for that reason alone, they would be better dealt with. No, it wasn't a freestanding reason, but the Court of Appeal judgment was months old, or just less than a year old. Target Ventures was obviously relatively new. Hasbro, Monopoly, about a year old. So it was novel, and by that point there was also the pending permission to appeal application before the Supreme Court in Sky. Were these matters important? Not really, because the test that was cited by the Court of Appeal was the correct one. So they obviously cited the CJEU test on what bad faith is: constant and relevant indicia, intention to use for a purpose other than trademarks, etc. So that test was right, but the actual application of that test, well, one only needs to see the divergence of findings between the High Court and the Court of Appeal, and the fact that the Supreme Court is now dealing with it. So, so far as the CJEU test was concerned, of course we accepted it, and that's difficult to see that changing. But whether it was novel, and whether it was, I think that was relied upon, and whether it was freestanding, I'm not sure that was right, that we did intend that. I just wanted to show one more paragraph on this, which is in the context of determining whether or not the claim is bound to fail. Peter Gibson LJ observed in Richards and Hughes that the court must be certain that the claim is bound to fail.
Can I just ask you about this? Although it's headed the law on strikeout, straight summary judgment, but I don't think the judge discusses summary judgment separately, does she,
No.
from what she says about strikeout.
No, there's a passage where the judge says that they more or less stand or fall together. I don't know if you can find that, but yes, it was put. One was discloses no reasonable cause of action, and the other is no realistic prospect of success, a reverse summary judgment. So I think the judge approached them both on the same basis. We did make mild complaint about the way that the applications had been brought. I mean, PD 24 has there's certain rules and hoops we have to go through to put in evidence and so on. And it seemed that by not putting in evidence, the Lidl derived something of an advantage, which was obviously not the way it should be. So I think that's what I wanted to show you on the law of strikeout. As I say, we say that those tests were not applied or were applied wrongly. This was not a claim that was certain to fail. It was a claim that was clearly inadequately advanced, and one that arguably, and I put it no higher than that, satisfied the test of bad faith. Now, how did the judge reach this decision? Now, it's difficult to see how, but it is fair to say that the law of bad faith has a high level of difficulty and a high level of, it could be said, vagueness. With any bad faith case, you are judging a course of conduct over a period of time, often a very long period of time, and as in this case, against what might be said to be a somewhat uncertain standard. We'll be looking at the test, you've read Sky Kick, and deciding by that standard, usually on a case where facts are unique. That's why it's a difficult area, and it's also tempting for any judge, and we say this is what really why the judge fell into error. It's tempting for any judge to look back at the cases and see, was this or that factor there? Is this enough? And there are some cases that suggest, for example, that the mere intention to use without more is not enough. But there are some cases that say mere intention may be enough. Mere intention not to use may be enough. There was nothing else in Kinder, for example. There are cases that suggest that the mere reapplication for a mark is not bad faith. There must be some additional factor. Now, we embraced in this case lack of intention to use plus the ulterior motive. The motive to have and hold a defensive mark sitting on the register for essentially for its scare value. That's what the purpose of defensive marks is. It's to create, in the case of a case like Kinder Snappy, a thicket of Kinder marks around the actual used ones. or in the case of the target case, an additional string to your bow when it comes to protection of the word target. And here it serves the purpose, the wordless mark, and we see it put front and centre, the particulars of claim. It serves the purpose of enhancing the protection of the mark with text, the logo mark, which is already registered. Of course, it was registered before SIDS, probably evergreened as well. And sorry, I withdraw that. I haven't. That was unfair. The position is that this is a mark which is, we say, arguably no higher than that, been applied for to enhance the protection of the main mark. But there are definitely difficulties in defining what bad faith is. I wanted to show you a quote by, a passage of the Advocate General's opinion in the Lint case, which was the first. Sorry?
She says it's almost impossible to define.
Yeah, she says, well, maybe just, she says it's almost impossible to define, and that, like a banker, you know it when you see it. You're careful to footnote that by saying that's the only thing that faith has in common with bankers. Let me just have a quick look at that. It's tab 4 of your authorities bundle. And this is an interesting case because it's the first time the CJU is dealing with the issue in any detail. And
yeah, it's paragraph 35.
Ungrateful. And I wanted to show you a couple of paragraphs after that as well, and where we get to. Like a banker, bad faith is no doubt easier to recognise than to define. I do not suggest that bankers and bad faith have anything else in common. It is a concept which not merely lawyers, but philosophers and theologians have grappled without quite achieving mastery. It is likely indeed that bad faith cannot be defined at all in the sense of determining its precise limits. Here we are concerned with bad faith in applying to register a trademark. The concept is not defined, delimited, or even described in any way in the legislation, but some guidance may be derived from its place in the scheme of that legislation, and that is a point that we see made time and time again in the case law, and in particular its relationship with revocation on grounds of non-use. Because the essential problem, put plainly, is you can revoke a mark after 5 years of registration if it's not used, but only first of all if somebody bothers to do so. So the register is currently cluttered with many unused marks, and until they are, so someone troubles to revoke them, usually if they're sued, they're going to sit there on the register. Which means that when someone does a clearance search to see if they can use a mark, they look on the register, and oh, can't use that, can't use that, can't use that. So they have a sort of scarecrow value. They sit there anyway, and they serve a purpose. And that is a problem, because for the first 5 years you can't do anything about them, even if you wanted to, unless you can invoke bad faith. So bad faith has an important role in dealing with a wide variety of circumstances where the mark should not be on the register, and you want to be able to allege that right at the beginning. Indeed, you can invoke bad faith, certainly as a UK mark, during the application. You can say that the application was made in bad faith. And of course, in the UK, we have section 32.3, whereby there has to be a declaration when you apply for a mark, the mark is being used, or there's a bona fide intention that it will be used in future by or with the consent of the proprietor. Now, just to show you one or two other passages in this, if you look at the 36 I've taken you to, 41, it's described as an inherent defect in the application rather than in the trademark, which fundamentally vitiates the registration regardless of other circumstances. And over the page, the Advocate General Sharpston is discussing the various positions of the Commission and other member states, and on the next page, about whether it's a subjective or objective test, and the Advocate General recommends an objective test, which is pretty much been taken up. And she comes to her conclusion at paragraph 60. And that's the concept of bad faith cannot be defined to a limited category of specific circumstances, such as the existence of a particular kind of prior right, a lack of intention to use the mark, or actual or constructive knowledge of the existence of a similar mark. It relates to a subjective motivation on the part of the trademark applicant, a dishonest intention or other sinister motive, which will nonetheless normally be established by reference to objective criteria, such as those listed under, which the circumstances such as those listed under 1 may well form part. And this is an important passage. It also involves conduct which departs from accepted principles of ethical behaviour with honest and commercial business practices, which can be identified by assessing the objective facts of each case against such standards. Now, it was put below, and in submissions and that letter, that it's about dishonesty. Not necessarily dishonesty as one may be given to understand that in the normal use. This is, first of all, dishonesty in the trademarks world. It's dishonesty in the making of an application for a trademark. But also, there's no requirement of dishonesty or falsification unless one is really expanding that concept to include failure to disclose your real reasons for applying for a mark. If one looks at a case like Monopoly, an evergreening case, where Monopoly, Hasbro, the makers of the board game, reapply for a mark, including for board games, and they do so that they don't have to trouble themselves with proving use if someone invokes the use provisions. There's nothing dishonest about that in the ordinary man in the street would not describe that as
Use of the trademark system.
It's an abuse of the trademark system to that extent, and fully would accept that. And in fact, Advocate General Tanchev used those exact words in the Skykick opinion. It is about an abuse of the trademark system, or an abus de droit, I think it's called in the Monopoly case. So this is it's important not to focus too much on the dishonesty basis, and even the Advocate General's opinion there that I've showed you puts a sort of alternative basis on the ethical behaviour of business practices and so on.
Well, the court says that at 37, 43 and 44 in particular.
Yes. And so I wanted to then turn to the Skykick case. You indicated that you'd read the authority, of course, and I wanted to show you just a couple of comments by the Advocate General. And you can find that tab 13 and paragraphs, 12. Thank you.
12, did you say?
Yes, 12. Paragraphs 93 to 101.
Sorry, where are you? Paragraph 12 of my Lord's judgment.
No, I'm looking at the Advocate General's opinion.
Right.
Just one moment. Yes. So if you pick it up at page 307 of the RPC report.
I think you mean 307 of the bundle.
Of the bundle, yes. And then paragraphs 93 to 94 of the opinion. Now, these are two sidelined pages, and I hope you had a chance to look at them. I just wanted to pick out a couple of highlights rather than read through the whole thing. But there is a lot there in terms of second variety of case, which is about abuses of the trademark system. 94, in my view, where the applicant was found by the referring court to have had a deliberate intention to acquire rights it had no intention to use, potentially inter alia to prevent third parties from using the registered mark, then there's bad faith. That is because the deliberate seeking of registration in respect of goods or services for which there is no intention to trade reflects an intention to abuse the trademark system. allowing the mark to be declared invalid on the ground of bad faith for lack of intent to use it in connection with some of the specified goods is in line with the objective. Now, 95 brings in this relationship with revocation. Now, I should say that in the US, you have to show use, broadly speaking, before you apply. Whereas we have a system in the EU and in the UK that you can apply, and then after 5 years, if you haven't used it, it gets revoked if someone troubles to do it. 95, there are undoubtedly advantages to permitting registration of trademarks without requiring actual use of them, as the European system does. Two of the key advantages are that it makes it easier for brand owners to obtain protection of their trademarks in advance of a commercial launch, and that it makes the registration process simpler, faster, and cheaper. However, if registration can be obtained too easily or too broadly, as in the present case, the result will be mounting barriers to entry for third parties as the supply of suitable trademarks is diminished, increasing costs that will likely be passed on to consumers. Over the page at 97, actually, at 96, just at the bottom, the bridging passage, I share the view of the referring court that if an applicant applies for a mark without intending to use it, there's nothing to stop the trademark being registered, assuming the mark is otherwise registrable, and the only way the registration be cancelled prior to the expiry of the 5-year period is bad faith. The Advocate General refers to another Advocate General, Cocotte, in the previous case, the Cotton case, and says that he agrees with her test on the basis that a test for bad faith is established from the moment when an actor obtains an undue advantage from the EU trademark system. A very broad test. Now, then goes on to cover the Cotton case, and at 99 states that the absolute ground for invalidity referred to in Article 52 applies where it's apparent from relevant and consistent indicia that the proprietor of an EU mark has filed the application for registration not with the aim of engaging fairly in competition, but with the intention of undermining in a manner inconsistent with honest practices the interests of third parties, or with the intention of obtaining, without targeting a specific third party, an exclusive right for purposes other than those falling within the functions of a trademark, in particular the essential function of indicating origin. Those words obviously are very familiar because they're in exactly verbatim in the Skykick case that followed hot on the heels. So this is very much the established test, and that's obviously why we weren't suggesting to the judge that this was not the test. The question is whether it was satisfied or arguably satisfied in this case, and we say it was. 100, the Advocate General says it must be the subject of an overall assessment, taking into account all the factors relevant to the particular case, and the applicant's intention at the relevant time is a subjective factor determined by objective circumstances. Over the page, just one last section I wanted to show you, the 105 and 106. This is in a passage where the French government is saying that if you allow bad faith to be too robust, too muscular, it's going to impinge upon the scope of the revocation provisions. It's going to deprive those provisions of their effet utile. And the UK government, who attended the hearing, showed how that is not so by way of an example. If somebody applies for the mark taxi for, let's say, 3 or 4 food products, and after 5 years they haven't, as a matter of fact, traded in one of them, then the mark is revoked. It's still intended to. There's a commercial rationale there. However, if somebody applies for taxi for biscuits, yogurts, cooked meats, and then also aeroplanes and surgical instruments, then the monopoly would prevent any producer of aeroplanes and surgical instruments from using the term taxi as a trademark for their company. And you can't do anything until 5 years. So for 5 years, you've got this right to complain about that. And the Advocate General points out that the focus is on the motivation at the moment of filing the application for registration of the mark, whereas for revocation it's necessary to focus on the use which had or had not been made. And so he comes to the view, I'm of the opinion that in reality it may be the revocation mechanism that potentially risks ridding the bad faith mechanism of its own scope of application, essentially rather than the other way round. So that was all I wanted to draw from the Advocate General's opinion. You've indicated you've read the judgment itself. That case was about a lack of intention to use for specific goods or services. It wasn't about the whole mark. So there's another issue in that case about whether there's the extent to which one can pare back the scope of registration as a result of the bad faith. So I wanted to then come to two kinds of cases. You've indicated you've read Target Ventures and Kinder. I wanted to show you the monopoly case, but perhaps if I'm going to come back to that anyway in relation to evergreening. Sorry, did my lord say that he read the monopoly case, or perhaps I should take their lordship?
You must take us to whatever you want to take us to.
Okay, please. Okay. Right. So then just to focus on the main test that was in the Cotton case and repeated in Skykick, which is 81 of the Skykick judgment on page.
Right, where are we? We're still in Sky.
We're still in Skykick, and I'll just pull that out and get it from there. It's then this becomes the test. It's cited in all cases that follow Cotton and Skykick. So if you pick it up at 330, tab 12, when they're dealing with the end of that particular question of what is the test, 81, paragraph 81, you can see that is the exact test that I read out a moment ago from Cotton. Now, it is accepted that the judge was faced with a difficult test, and it's a test where it might not be easy to apply it to any particular fact pattern. But that was a point in my favour in a strikeout, not in Malone and Friends. That was a reason to say that in fact you couldn't be certain that at trial these allegations would not be made out. And it was not a reason to say that the case should be, that the counterclaim should be struck out. I think that's probably enough on the test itself, but we say it was clearly satisfied by the pleading, which I'll show you in a moment, and we say that courts and tribunals face an unenviable task considering this kind of test, but it is one that is an important one, serves an important public interest. So I wanted to show you then the pleaded case. If you could take, please, the counterclaim, which is in the core bundle.
I don't think we've got the counterclaim before it was struck out.
Right.
So it's all stuck through in green. So speaking
You've
for
got
myself,
the only
I've
one,
been working on the judge's quotation from it, which I find rather
yes,
easier
actually,
to read.
that may be the best place to look, because I was going to say, unfortunately, the only hard copy there is of it is the struck-through version. So if we then take the judge's... Paragraph 24. 26.
Yeah, it's 24 to 26.
Yeah. So
Can you
24
help me on
is
this? I
sort
don't think it matters at all,
Yeah.
but just says that my understanding is clear. Paragraphs 47 through to 49, I think. I may have got the numbers not quite right, but anyway, the paragraphs in the counterclaim were struck out. But 4.10 and 4.11 were not struck out. Is that correct?
Does that they were struck
Where I was
That
getting
they
that
were,
from is paragraph 3 of the order. So if we look at core bundle tab 2, page 16,
Yep.
under the heading strikeout application, it says that it succeeds. Paragraphs 46 to 48 are struck out. And there's a reference in paragraph 4 to amending 4.10 and 4.11. But they don't seem to be actually struck out.
No. I mean, they were struck out in the sense that they were removed from the case because they relate to the bad faith counterclaim.
Right. Okay.
My lord can see that at page 115 in the core bundle.
115.
115, yes. They were filleted, I should say, rather than being struck out in whole.
Right. So we read in implicitly that 4.10 and 4.11 are deemed to be struck out to the extent that they follow 46 to 48.
Yes, we can supply, my lord, with the struck out. Sorry, I hadn't approved. If you've got the green.
Yeah, we've got
Yeah.
that.
Oh, good. Okay, so if you look at page 115.
Yes, Mr. Brander's just told us to do that.
You can see that the reason for that is because there is another counterclaim for invalidity based on distinctiveness. So there are bits that remain.
Yeah,
Apart from
non-use.
anything that related to bad faith is gone.
Yeah. Thank you.
So the I think we were looking at that judgment on page 30. Yes. What is said in the first part struck out, so 410, is it is said that the trademark does not exist.
Sorry, you've lost me. Where
Sorry.
are we in the judgment?
We're back in the judgment, page
Okay.
28, paragraph 24,
Right,
tab 3. And it is said that Lidl have illegitimately obtained trademark protection and that it should be expunged. Now, this came from an earlier part of the pleading where each side had put in a sort of summary, précis, of their case. And it was said that they've never used the wordless mark, never intended to use it, that they argue that its use is validated by use as part of the mark with text. They argue in the proceedings, but there is no legitimate reason for Lidl having applied for it other than to extend the protection. I'm not sure this says a great deal more than is already said, than is said in the pleading. It's intended to be a summary paragraph. And it then goes on to say it was applied for the sake of legal protection per se, for its value as a legal weapon. And then it goes on to link that to the evergreening arguments. So, not much to say there other than actually pleaded later on. If you turn over the page to paragraph 26, we've got the 1995 UK application, UK mark, the numbers are given. It is said that it's a legal artifice with no corresponding mark in the real world. It's never been used in the form appearing on the register. Now, it's important to note what's meant by that. This is not merely an allegation that it hasn't been used alongside another mark. It's quite common for marks to be used as a composite, shell device plus shell word. this hasn't been used because it doesn't exist. There is no blank yellow circle out there in use. Now, it was accepted for the purposes of these proceedings that that was so, and there was a suggestion that there might have been some use in advertising in response to a Part 18 request. In other words, in the exact form. But that went nowhere. And it was quite difficult to know what to make of that, because the judge seemed to think that was a point in Lidl's favour, but we suggest that that is very much not, because they accept in these proceedings that they haven't used. And there is no evidence of use of the blank desk. It's never been shown. And so that's simply an assertion which suggests that, and runs contrary to, the argument that they intended to use it as part of the mark with text, which we say is unlikely anyway, but it does cut across that. So we say that they devised their logo corresponding with the mark with text in 1987. There's a reasonable inference that at least by 1995 there was no bona fide intention, if there ever was, which is denied, to use the wordless mark in the form as registered. This is supported by the lack of use of that mark in the period both before and since the date of application. Now that's an important point for this reason. Imagine if we were having this hearing in 1997 and they'd only applied for the mark 2 years earlier. It might be said, well, okay, they haven't used, but you might say it's a defensive mark, but got 5 years to do so, they might use it. How do you know? We know they haven't, and they haven't for nearly 3 decades. And that itself is an important ex post facto factor which can be taken into account on the date of application as to what the motives of the applicant were. Now we say that in 47.3 it's denied that use of the mark amounts to use of the wordless mark, but even if it did, that would have no bearing on the bad faith nature of the application. We say they had no use or no need to apply for the wordless mark unless the purpose was to give little wider or different protection. Now, there's a small point, which is that at the hearing, the learned friend accepted that, indeed submitted that.
Well, that's the point that divides you, because Lidl's case is, yes, of course they applied for the wordless mark to get a wider scope of protection. They say they're entitled to do that, and there's nothing illegitimate about it.
Yes.
Whereas you say that is illegitimate.
Yes, and that should be resolved at trial,
yes.
What we say. And really that's what it comes down to. It wasn't inappropriate, we say, to simply, if a question is raised as to use, that somehow means that the question is answered and it should be assumed that the intention is unobjectionable. So we say the result was an application, just looking forward to 47.4, made solely for the purposes of deployment as a legal weapon, not in accordance with its function of being used on goods or services to indicate the origin thereof. And that's really the first part of the pleading. Now, we say that was enough right there. You didn't need to get into evergreening, and the evergreening is reasonably complex factually, but it was a part of the defensive mark strategy. We say it makes sense that it was, because if it's vulnerable to use, why not evergreen? But it was not essential. Even if there'd been no indication of any reapplication, that should have been sufficient. Now, is that enough? There's lots of cases that suggest that with bad faith, it's a serious charge. It's got to be pleaded up front. The trademark proprietor needs to know the case it has to meet, and so on. And of course that is right. But the problem is that a defensive marks argument is ultimately quite a simple one. You've applied for an overlapping piece of a mark that hasn't been used, and the purpose of that, it is to be reasonably inferred, is to sit on the register and expand the scope of protection, or even be deployed in infringement proceedings as this has been. And that really was it. Now, just to, I think I've probably already attacked at least, or tried to attack the point about whether revocation on non-use somehow validates the original intentions. But the point is that since the judge...
Sorry, just say that again.
Sorry.
Revocation for non-use validates the original intention.
Sorry, there's a stream of trademark buzzwords. Let me try on. So, under section 46.2,
Yeah.
you can save a mark from revocation
Yes.
where it has been used effectively in a variant form. Yeah. And we've applied for revocation of the wordless marks on the basis that they have not been used, and that has been met with the argument, yes, they have been used under section 46.2. So the wordless mark is a variant form that doesn't change the distinctive
I think that's the
character.
alternative case, isn't it?
It's the alternative
The
case.
primary case is that if you use it with the text, you are still using it without the text.
Yes, yes. It's sort of overlaid.
Sort of the greater includes the lesser.
Yes, but we said it doesn't work because the wordless mark is blank. So it isn't overlaid with the mark with text. The mark with text itself has a blank background.
Yeah, well, you say neither argument works, but again, those are both issues for trial, and that, as I understand it, is common ground.
And most importantly, they have no bearing on the issue of bad faith. In the Specsavers case, where this argument about variant use comes from, there was no argument about bad faith, about whether Specsavers had tried to enhance their monopoly. There'll obviously be other arguments at trial about that, but it's important to note that there was not such an argument in Specsavers. Now, another area that we say that effectively the judge got wrong was in accepting the submission that there was nothing wrong with overlapping protection as a matter of principle. Overlapping protection is fine. And you will have seen from our supplemental skeleton, we say that begged the question in issue. It may be fine, it may not be. It depends on a number of factors: the intention of the applicant, the nature of the overlap. So, for example, Kinder Snappy, they all overlapped with Kinder. They all overlapped in that particular respect. Bad faith. And in Target Ventures, they overlapped on the word target. So it isn't right to say that overlapping protection is always a fine thing. It may be bad faith. And indeed, we say a case such as this is interesting because the element itself, as we've just been discussing, is a sort of abstracted element from the sign as used. So it's not an element, a freestanding independent element. So the word Lidl would be. It's an element that is in the substrate, or it's included in the whole. And that's why we say it really is, it has all the look of something that has been applied for in bad faith as use as a defensive mark. Now, I'm just going to then move on briefly to evergreening, and I hope that will pretty much conclude my submissions in opening. The evergreening aspect of the case is one where the judge, it appears, did not consider that there was anything wrong with reapplying for a mark. And that may be so, but again, it begs the question. Some reapplications may be abusive, some may not. And the judge was certainly in difficulty because there's never been, as far as we're aware, an evergreening case in this country. So there's never been a successful case of bad faith brought on the basis of reapplication. And indeed, for many years, it was thought to be unobjectionable. That's what you pay lawyers for, to extend your mark, and extend your mark because it's running out of time, and to avoid proof of use. Whether people felt anything ticklish on the back of their neck as they did that is a matter for them, but it is certainly something that went on and was widespread. The submission in the monopoly case was everybody's doing it. What's wrong with it? What harm are we causing? Now, the harm is really this. If you look at the facts of a case like Monopoly, Monopoly had applied for that word for essentially board games and a number of other things. But they'd included board games. And their view of the matter was it was completely justified. Monopoly is a household name brand for board games, has been for decades. There's no question that it's being used. And there's no question that if they were called upon to show use, they would succeed. So why can't they do what they did, which is just keep it all up to date and avoid this pesky 5-year obligation to show use? And indeed, rather than call that bad faith, much less dishonesty, it might be said that Monopoly were behaving commercially prudently. And certainly there was an argument to that effect. But the problem is that approach creates a widespread systemic problem. Because if you are allowing people to reapply for the mark after the 5-year grace period is over, or even before, or even 10 years later, if you're allowing them to reapply for a mark, they get to avoid proof of use. And that may be significant for a number of reasons. They may have narrowed their use or broadened their use or changed their use. And don't forget that the mark isn't always completely revoked after 5 years. It may be partially revoked. So if you've got clothing, but you've only ever sold wedding dresses, then you keep wedding dresses. You don't get to keep clothing after 5 years. So rather than avoid that consequence, any party can say, reapply, just reapply. Now, the reason that's a bad thing is because, first of all, trademarks are perpetual monopolies. Perpetual monopolies that can be renewed every 10 years with the payment upon the payment of a relatively modest fee. So you've already got a mark. You should be able to operate with that and subject it to proof of use after 5 years. And this is a mark that you apply for. So with trademarks, unlike most other intellectual property rights, where you've got to do something to get the right, you've got to design something or invent something or write something in copyright, compose something. Trademark, you just create your own monopoly. You write it down and you pay a modest application fee for whatever goods and services you like. And subject to other people's rights, you get it. And so in those circumstances, to allow a party who has applied for and got a mark on that basis to then reapply effectively permanently, evergreening is a mild and rather delicate way of describing what they're doing.
Well, again, the gravamen of the complaint is that it's abuse of the trademark system.
It is an abuse of the system, yes, and it is not expressly precluded by any rule in the system. So there's nothing that says you can't do this. And it'd be difficult for them to actually draft a rule that said you can't do this. But the quid pro quo must be vulnerability to revocation, and so it is a bad thing to ever...
You mean a declaration of invalidity on the ground of bad faith?
A declaration, sorry, yes, normally the quid pro quo for drafting your own monopoly is, yes, you can do that, but after 5 years you're going to lose it, or part of it. But if you don't have the declaration of invalidity, as Lord Justice Arnold just said, then you've really got nothing to stop this going on. We say that in any action for bad faith, the party alleging it must plead the action, which it says evinces the bad faith intention, and it must identify the intention. And we did that when it came to the defensive marks, and we say we also did it when it came to evergreening. There's no requirement that the facts be only consistent with good faith, as the judge rightly held, and so really that should have been that. Now, I wanted to show you briefly how evergreening works. The important point to bear in mind is that there's no requirement that the goods be identical, goods or services be identical. Indeed, they very often are, but a clever evergreener will perhaps use synonyms or broader terms that include the earlier terms, or narrower terms that are included by the earlier term. And so that is still evergreening because it still gives you the benefit of effectively the same mark for at least some goods. And in monopoly itself, they didn't lose all of the marks for all of the goods. The whole applications were not infected, so to speak, by the bad faith. They were partly cancelled for the goods and services that had been reapplied. So,
just to go back to your wedding dress example, if you apply for a mark which is going to apply to wedding dresses, and you decide after a while that you want to sell a broader range of clothing, you would presumably have to reapply
Absolutely.
for that mark,
yep,
but this time with a broader specification.
absolutely. And we confess to accepting that not all reapplication, so to speak, in the way that I've described, is going to be bad faith. And there may be other reasons. You may be, a friend relied on the fact that, of course, there was an expansion into European marks from UK marks. And of course, some of the marks now have come back the other way. There were EU marks, and they've now been effectively given rise to daughter marks, or, comparable marks in the UK, and so on. There may be, but the question is it arguably bad faith? Is it a particular of bad faith? Is it relevant to the allegation of defensive mark registration that there has been evergreening? But actually, and I'll show, my lord, by reference to the table in a moment, that there was some direct copying over as well. And no evidence, most importantly, from Lidl as to what their commercial intentions were with each application.
Well, that's partly why I wanted to ask you about strikeout versus reverse summary judgment. Because we're looking at striking out, we're just looking at the pleadings, aren't we? We're not looking at evidence.
Yeah, that's right. We say we defend both bases, obviously. We say that the pleaded case was named
Did
the marks.
the judge actually give reverse summary judgment? Where does she deal with that?
It's
Struck
40.
out.
Yeah, it's paragraph 40. In a case such as this, where the strikeout application is based on the nature of Tesco's pleading, there is no difference between the two.
Yes, so she wasn't looking at evidence. She was saying, on your pleaded case, you are
Correct.
bound to fail.
Yes, yeah. But we say that.
So she, inherent in her decision is, let me assume that you prove there was no bona fide intention to use the wordless mark, that the purpose of the application was to give little wider or different protection, that the purpose was to use it as a weapon in legal proceedings, not for the function of being used on goods or services. So if you prove all that on the facts, you still fail.
You fail, exactly. And that is why we say, I mean, when I said there's no evidence of this or evidence of that, the judge said it didn't matter because your pleaded case doesn't hit the standard. So I just wanted to then show you the table, and I don't know whether have they had this in landscape or something? You got it in the electronic form, did you? The annex to Mr. Whitehead's statement?
I'm afraid I haven't looked at it, but I gather we've been given a hard
Yes,
copy.
I can show you just very quickly. I mean, it's
Teeny weeny. It's teeny weeny.
Oh, is it?
very small. That's the problem. Yeah. But fortunately,
And I've lost it.
the relevant goods
Oh my
and
goodness.
services are read when they are identical, underlined when they're similar. And you read from, if you're looking at it in normal portrait mode, so to speak, the page on tab 4, you read from the back.
Sorry, where is it in the...
So supplemental bundle, tab 4.
We read from the back, so we're starting
Read from
page
the back.
37, are we?
You've got 37, and you've got the UK mark.
Yeah.
And I can cut through this very, very quickly, as I did to the judge. And you can just, there's only a few pages here, but you can see from the sea of red and underlining that there's been a lot of duplication and semi-duplication. But this is in circumstances where you've got permanent monopoly. You don't need more marks. unless you want to apply for broader or better goods and services. But just taking it from paragraph 95, sorry, the mark from 1995, it starts out with a sort of meat, fish, coffee, tea, and a few things. Now, of course, in 95, Lidl were a retailer, and they applied for a small number of things. And then also in this, by the way, you can see from the numbers that it's got UK 000201665 and then the other one next to that is C. That means that they were, I think, divided. They were originally one application, and then they get divided. I assume that's what happened. And then over the page A. So the mark is divided, but it's essentially, it becomes 4 marks initially. And you can see from the goods and services, there are sweeteners, cutlery and forks, looking at the 95 mark on the right-hand side of page 35. And if you turn over to page 36, you can see there's a certain amount of duplication there, but not a great deal. But those are UK marks. Now, one of the things that was said by Lidl is no evergreening, because we're entitled to apply for EU versions of our UK mark. This Swish new EU trademark system, where we wanted to use it and get a unitary right for the same goods and services. And we did that. Let's assume that's right for present purposes and simply move forward. And we can find that purely by looking at the 2002 EU mark, which you'll find on page 35 on the left-hand side, the 2005 mark, which is on the previous page 33 on the right-hand side, and the 2007 mark, which is on the left-hand side of that same page. Now, we have, just to put it very simply, on the top of page 34, left column, retail services in relation to foodstuffs. That all those red words are copied out from the column next to it, which relates to the 2005 mark. So you've got 2005 mark originally had retailing services for a bunch of things, and then you had the 2007 mark for retail services for a bunch of things. Now, there's a lot more copying out, but that's just very simply what's going on there. And then most recently, we have, if you look at the first page, page 30, that's a UK application that was made in 2021 that has vast amounts of copying out and vast amounts of underlining in it. Now, that was recent. My learned friend says, I think in his skeleton, if we were evergreening, we were pretty bad at it. We only ever relied upon marks that were subject to proof of use. But you didn't have any marks that weren't subject to proof of use. So to that extent, you might be bad at it. But the fact of evergreening, or the fact of reapplication, may still be an abuse if it's applied for the purposes of avoiding proof of use. So if I know I'm going to sue somebody in 10 years' time, I check my portfolio and I update my mark by reapplying for vast numbers of goods and services that are identical. That's bad faith, or likely to be bad faith, or in my case, arguably bad faith. And so there's no reason for the 2021 applications that you can find on page 30. They were applied for even after this dispute began, perhaps with the intention of being added in or something to these proceedings. Anyway, they're currently stayed. But if you look at the sweep of their registrations, there is extensive, and that, by the way, is UK, so that's UK versus UK, and I've showed you EU versus EU. And so we really do have, we say, quite plain case. Now, is it wrong to reapply for trademarks in this way? Not always, not necessarily. It depends. And this was a case where Master Pester at the CCMC ordered disclosure of Lidl's intentions and commercial rationale when applying for the mark under Model D. And we expected to get that in due course. And there may be perfectly good answers to these points. My learned friend has suggested about 5 different answers on his feet before the judge. It was said, for example, that the marks are different or slightly different.
So just pause a moment. You say the master ordered disclosure of documents
Yes.
related to intention. Have they been disclosed?
No, because of course it was contingent on the outcome of this application.
Oh, I see.
So we never got it. And my Lord Justice Arnold will recall from the Skykick case that there was no disclosure in that case of the commercial intentions, and the man who made the decisions wasn't called either. But of course but there was cross-examination of Mr. Tansey, and that was rather important to the outcome. What Sky's motivations were, what its rationalisations were, and so on. That's what these cases are about, and that's completely invisible to us on our side. And the question is whether we raised a prima facie case that disclosure should happen, evidence should happen, and that should be tested in due course.
Yeah, well, the problem is you get the claim to privilege.
Yes, of course, in disclosure, and that's what happened in Skykick. But one hopes that there could be something, and if the issue's in the case, then that can be tested in cross-examination. But if my lords wish me to look at monopoly, essentially it says that this sort of behaviour can be an abuse of the system. Abus de droit is another way of looking at it.
It's not a question of whether we want you to look at it. It's a question of whether you
Yes,
want us to.
I'm trying to see whether my lords. I think I was secretly trying to see whether my lords are interested in the point or not. I will take.
If you're in abus de droit territory, that applies where you haven't done anything that
Correct.
is formally contradicted
Exactly so.
by the law.
Exactly so. And in fact, the court doesn't quite go so far as to say it is an abus de droit. They say it calls to mind an abus de droit, where essentially you're taking
Can
an
you
advantage.
remind us where they say
Yes,
that?
I will. I think I'm going to just go through. There's only one case on Evergreen in the state.
Where are we going?
So we are looking at tab 6 of the authorities bundle, and I've sidelined quite a bit of that. But I'll try and really point out the important parts. Just by way of factual background, on page 80, you can see that registration was sought as a mark for the word sign monopoly. And in class 9, there were various goods. But do you see in class 28, they applied for, at the bottom of the page, games and playthings.
Yeah.
And it then says at 6, the applicant was the proprietor of 3 EU word marks, earlier marks, and that had paragraph 7, class 28, toys, games and playthings, and some other similarity. And you can see from the class 9 specification there's some overlap because it includes some of the items on the other page, on the facing page. And the point here was that Hasbro said essentially they'd done nothing wrong. The rules were not, did not preclude reapplying in this way. And the court was faced with the question, by the way, this is a case, this is quite an unusual case, that before the Board of Appeal they had a hearing. Normally they don't have hearings, it must be one of a handful of hearings. It was also the Grand Board of Appeal in the EU IPO in Alicante. And then it was dealt with by the General Court, the 6th Chamber Extended Composition, which again is unusual. The court was called upon to consider the test of bad faith you can see that at page 84, paragraph 32, where they essentially summarised the cases that have been looked at already. The Lint case, the Cotton case, the 32. And this was the passage I think I referred to in passing in opening 36. It's apparent from the wording used by the Court of Justice that the factors listed in Lint are only examples drawn from a number of factors which can be taken into account in order to decide whether an applicant for registration was acting in bad faith. In that judgment, the Court of Justice confined itself to answering the questions of the National Court. Consequently, the fact that any one of the factors is not present does not necessarily preclude, depending on the particular circumstances of the case, finding that the trademark applicant acted in bad faith, and they cite Copernicus. That's an important point in this case, because the judge was faced, to be fair, with no previous case that was on all fours with this case, no previous UK evergreening case, and certainly a defensive marks point that is difficult to follow, perhaps, or difficult to find a case that's exactly right, certainly one based on a device rather than a word. And so, really, that it's important. We say that the judge was likely to have considered that the absence of a case like this told against Tesco, when in fact it should not have. The rest of the factors identified in those paragraphs are fairly standard. 39, consideration must be given to the trademark applicant's intention. At the relevant time, it's subjective, to be determined by reference to objective factors. It involves conduct, in 41, which departs from accepted principles of ethical behaviour or honest commercial practices. It is for the applicant to, who intends to rely, I think we've cited this part in our skeleton, it's for the applicant for a declaration of invalidity who intends to rely on Article 52 to prove the circumstances which make it possible to conclude that an application for registration as an EU mark was filed in bad faith, the good faith of the trademark applicant being presumed until proven otherwise. Where the EU IPO finds that the objective circumstances of the particular case, which were relied upon by the applicant for a declaration of invalidity, may lead to the rebuttal of the presumption of good faith, which the proprietor of the market issue enjoys when he or she files the application for registration, it's for the proprietor of that mark to provide plausible explanations regarding the objectives and commercial logic. That comes close to an approach of an analysis of sort of what's required to be pleaded, what's required to be.
Well, I mean, if we go back to 42, transposed to a strikeout application, we should, I would have thought, read it. It is for the applicant for the declaration who intends to rely on the article to allege the circumstances which, if proved, make it possible to conclude. So
yes. What they are sort of hinting at, of course, it's a completely different evidential system and procedural system. In the following paragraph is a sort of shift in the evidential burden. So what you've got to do is you've got to raise the objective circumstances.
if you prove what they talk about in 42,
Yes.
then you've shifted the evidential burden.
Yes, yes. It follows on from, yes, I suppose 43 follows on from that. It goes on at 44 to say that it's the proprietor of the trademark at issue is best placed to provide the EU IPO with information regarding his or her intentions. And that is really a point that bitter experience tells. You know, the difficulty of getting disclosure, the difficulty of getting anyone to talk about the intentions, the reticence on the part of the party to and very often, as in certainly in iKick and in this case, they say they've done nothing wrong. They just confess to it, or they say there's nothing wrong with broad protection. But sometimes they also say nothing.
Well, it goes further than that, because it's often the case in these types of cases that the trademark proprietor genuinely believes that it's done nothing wrong.
Exactly.
But the case law shows that the fact that you yourself don't believe you've done anything wrong is not an answer to a charge of bad faith.
It's not. It's not. And it's not surprising that a party with well-established trademark rights considers that they should be able to apply for a lot of things, and with clever lawyers, they seek to get whatever rights they can. So we say,
I think you started this by telling us that the court referred to the abuse of rights principle.
yes, yes, but I wanted to show you a bit more of it as well. So the over the page we've got the relationship to the use provisions, which I think I've probably already submitted, made submissions on. 54, the ratio legates for the requirement that a mark must have been put to genuine use is that the entry of an EU trademark in an EU IPO's register cannot be regarded as a strategic and static filing, granting an inactive proprietor a legal monopoly for an unlimited period. On the contrary, the register must faithfully reflect what companies actually use on the market to distinguish their goods and services. There's sort of a transparency of the register consideration there. 57 is, I think, quite a passage relied upon by my learned friend. In the third place, although repeat filings of a mark are not prohibited, the fact remains that a filing which is carried out to avoid the consequences entailed by non-use of earlier marks may constitute a relevant factor. And that was the allegation here. We pleaded specifically the intention that the intention behind the reapplication was to avoid the use provisions. And actually I should probably just show you very quickly, again by reference to the judgment rather than the struck through passage.
It's 48.2, isn't it?
Others ahead of me. Yes.
And 48.4.
Yes. 48. So it's page 29, tab 3 of the bundle, of the core bundle. As regards the additional wordless marks, Tesco will contend. 48.1, the additional wordless marks and the 2005 version of the mark, namely the EU marks, from which those comparables derived, are evergreen versions of the 95 mark, in that they duplicate coverage of various goods and services covered by the mark. Just pausing there, the judge was unhappy with the vagueness of the words various goods and services. For the strikeout, we filed that evidence, which had the annex, and I think we said that to the extent that necessary, we would be prepared to annex that. We've obviously lived or died by that particular annex, and we say that was very, very clear. So we go on to say, further or alternatively, as regards the additional wordless marks, they were, we say 48.2, there was no reason for Lidl to reapply for the same marks and goods and services other than to avail itself of a fresh grace period during which it would not be required to show use of, in effect, the same mark. And we say, in the circumstances over the page, they're probative of bad faith as regards the marks themselves and the 95 mark. It is sort of said that the whole thing is self-supporting and circular. Well, it is. It's exactly right. If you apply for a mark in 1995, you're obviously not evergreened anything because there's no previous mark. But if you then apply, let's say, 4 years and 4 days afterwards for a second mark, then that's probative of bad faith in relation to the first mark, because it gives you some indication for saying, well, that you're doing that because you knew it wouldn't be used, or maybe you only just, it's not completely conclusive, of course, but it's at least relevant to whether you had that intention, and it's also relevant to the intention in relation to the later mark. Just in the same way that if we've got recent applications in the UK for the same mark with duplicative protection, that's probative, generally, of a plan of evergreening, or strategy of evergreening. We don't know the details and we haven't been given disclosure or evidence on this, but it's certainly relevant to it's certainly material that would be relevant to a finding of bad faith. We go on to say in 48.4 we refer to other marks, and we then repeat in 48.5 that Lidl made the applications not in accordance with the functions of a trademark, but purely to obtain exclusive rights for ulterior and illegitimate purposes. And then we rely on the 2021 marks. Well after this dispute began, we say they represent yet further attempts to evergreen and benefit from fresh grace periods for those marks, and they've been stayed. Next page. So,
Use of rights.
that's
paragraph
72. Yeah. That was the only other thing I was going to get from this case. I mean, just to say, 72, page 88, calls to mind an abuse of law, which is characterised by the fact that despite formal observance of the conditions laid down in EU rules, the purpose of those rules has not been achieved. And secondly, there's an intention to obtain an advantage from those rules by creating artificially the conditions laid down for obtaining it. We say that is, obviously, there's no direct provision precluding Lidl doing what they've done, but that bad faith or abuse of law, which may be a sort of species of bad faith, is a way of dealing with it. The only other point from this is whether the bad faith intention has to be the only intention. That is a complicated matter, but we say the Court of Appeal has gone wrong on that point in Skykick, in arguing that in the Skykick case itself, and that there's no requirement that it be simply the only intention in carrying out the conduct complained of should be the desire to get a fresh grace period. It's a question of assessing the significance of that factor. Now, in the Hasbro case itself,
Well, just a minute. If you say that's what the Court of Appeal decided, unless and until the decision of the Court of Appeal is reversed, we're bound by
Well,
it, aren't we?
I wanted to show you the passage in question because it's potentially per curia. It's not a finding. I think it's been interpreted wrongly, is another way of looking at it. We say that it's clearly not what the Lint case says. But actually, as I said in my skeleton, this point probably doesn't matter because we allege that that was the sole intention. And there isn't any answer to that. So it may be that one doesn't even need to consider this point here. But for what it's worth, in the Hasbro case, of course, they said many good reasons for reapplying. They said they wanted to tidy up their portfolio and save administrative costs and so on. But the fact that they had applied for example, even monopoly for board games was suggestive, according to the court, that there was bad faith or there was this abuse of law. A point is said finally, I think, that the marks are different or that there was some sort of evolution in the brand. If you still have the supplemental bundle, and we were looking at the table, yes, well, so the first point is that this, I don't want to spend too long on this because again, this was a pleading case, as my Lord Justice Lewison said. It doesn't really matter what Lidl said in response, but we make a point that the judge should have been alive to the fact that these justifications for the conduct sort of arrived in a various number of ways. It was said in the letter from Bird and Bird attached to the application notice. I'll just read it, there's no need to go there. It is said, as to the subsequent applications, it is not explained why evergreening, as it is alleged, is indicative of bad faith in cases even where the marks are identical to earlier marks. But here they're not identical, either as to specification or as to territorial scope of protection. Moreover, the sign differs in respect of the colours used, reflecting updated brand guidelines. Now, we sort of struggled with that because, first of all, it was said in a letter. It's not form of any evidence, and actually it's inconsistent with the appearance of the marks themselves. You've got copies of the actual marks at the back of this bundle, and you can see how they are described. If you take tab 10, page 109, you've got first of all, so far as the actual representation appearing on the register in colour, that can sometimes be a bit unreliable because it depends on when the mark was applied for, whether it was scanned, whether it was photocopied, and also it varies in terms of the user's monitor and so on. So it can be a bit unreliable, but there isn't any indication that the colours do vary. So if you look at 109...
Won't they be specified by reference to a Pantone?
Well, that's the thing. So some of the marks are, some are not. Some are just red, blue, yellow.
So 109 is an example of that. There's no Pantone reference.
There's no Pantone shade in 109. And so that is just simply as it is. The mark is as shown. It's depicted in heraldic shading. I'm not sure that is heraldic shading, but anyway. So then the next one, that's 95. And then, sorry, these are all in the series, so these are the same mark. Then we next come to, that's coming up. What happened then was there was an ECJ authority that said you've got to include Pantone shading, and parties started to do it. We've got, actually these are not necessarily in the correct order, but these, point I wanted to make, either say yellow, blue, red, or they specify a Pantone shade. But of course, if they say yellow, blue, or red, if one says that and the other says a Pantone shade, then they're the same because it's broader than specifying Pantone shade. It's effectively red in the abstract.
So the first Pantone one I found is 131.
Ungrateful rules, yes. I think that may be the only one, actually. These are not colour marks as such, and that may be why there was a flirtation with using a Pantone shade, and then it was abandoned, because we've got 2007, we've got the Pantone shade, and then later, marks I've shown you, it's dropped, and before it wasn't included. But what standing back we have is pictures of marks which to the consumer would be considered to be identical. They are described in a way that is identical to the extent that the broader claim includes the narrower. The marks are identical, and indeed they were pleaded as being identical. So there was effectively a theory that there was some sort of updating of brand guidelines which didn't seem to be supported in any way by either the appearance of the marks or, of course, any evidence. But it may not matter, because when I pointed this out to the judge that we were unhappy with the way that this had come out, it was said, well, it said in the judgment, well, it doesn't matter because it's all about your case and whether you've got a case to begin with. So the evergreening case has its own sphere of application, but it's also linked to the defensive marks appeal by virtue of its the motivation that you have with the defensive mark to evergreen. Nothing further, my lords.
Thank you very much. Yes, Mr. Brandreth.
My lords, my lady, I understand there's a transcript writer, and I don't know whether your lordships, my lady, wishes to give a brief break.
No, I don't.
Very well.
That was the condition on which I agreed to having a transcript.
Very good. My lord, I have developed submissions to make, but I think it's helpful to begin by picking up immediately on a few of the points that my learned friend has made in particular by reference to the questions that your lordships and my lady have asked. And there are only 4 of them, and I foreshadow them rather than going into the detail. It's just to show you I'm aware that you'll want answers on them. The first, I think, is this point about that my learned friends kicked off by taking you to the letter that we raised and suggesting that there was some tension in our position. It was then followed by a question that my lord asked about the basis on which the judge at first instance had dealt with my application, the assumptions she had made moving forwards. And the issue that it raises is this. We say that what my learned friend does, his error, is to identify to you an abstract case of bad faith, when the challenge that we put to him was to identify the objective circumstances that he relied upon that meant that that challenge needed to be met at a full trial. And what we say after a day of pre-reading, 2 days of argument, we persuaded the judge at first instance was that those reasons why they said there was this abstract case of bad faith could not possibly succeed in allowing the inferences that they claimed they did. And it's on that basis that we say that we succeeded, and why we say perhaps it's understandable that the judge at first instance didn't dwell on the difference between strikeout and summary judgment. The reason I pick it up is because my lord said, well, do we assume that there is a defensive mark here, and then proceed to ask whether or not they could possibly succeed on that basis? We say that that is the allegation, the ultimate point that they try to prove. And we are at an earlier stage. Have they raised inferences that mean that that allegation is something that needs investigation, having regard to what we say is the starting point, namely the presumption of innocence in this case? Now that, I think, feeds into another point that my lord made to us, which I rather pejoratively am calling the Lady Bracknell point, because my lord asked, well, don't you have to look at all of the things together? To lose one parent may be considered, etc., etc. Is there a concatenation of circumstances which together, although individually unsuccessful, together allow you to conclude that there is something worthy of investigation? We make 2 points here. The first, we say, is that one cannot add 2 and 2 and make 5. A series of perfectly legitimate matters cannot, by their combination, become something illegitimate nor indicate the presence of suspicion of illegitimacy. But secondly, we say that in fact, my lords, my lady, when you look at the pleaded case, there is really only one point here. They look at the fact that the wordless mark is to be found in the mark with text, and from that they then draw out various matters that follow from that. But it's really that initial question, are you allowed, is it lawful to apply for such a mark, that they point to? And we say, therefore, that there isn't really, on analysis, a concatenation of issues. There's really only one. And that's true also of the evergreening point. Because the way that they plead the evergreening point, and my learned friend took you to it, is that the only reason, those are the words that they themselves put in their pleading, for us to have reapplied for marks, is because we knew that we hadn't made use of the wordless marks as they were originally filed for, and therefore felt that we needed to reapply in order to protect them. In other words, it comes back to this issue of whether or not you're entitled to make these kinds of registrations. Now, I want to expand on all of that, my lords, my lady, but you see where we're going to go. Can I just add 2 smaller points? Paragraph 4 and it being struck out, I think this is really a very minor point, but we say the reason why paragraph 4 isn't at the forefront of the order is that which I've given at 32D of my skeleton, indeed which my learned friend in his submissions to you echoed. It's just a summary paragraph, and therefore it wasn't being dealt with as if it added something to the meat at 47 and 48. The second point is something that my Lord Justice Arnold raised, which is this issue of whether or not one can have these overlapping marks. My Lord said, well, this is the point that divides you. One of the arguments that I do make to your lordships, and I made to my lady, although she didn't rely upon it, is what I call, in summary, the McBride reasoning. My lords, my lady may recognise that from the judgment. Where one seeks to make an inference of bad faith, And the point that one relies upon is a disputed point of law which you accept is arguable, so it's not strikeable. We say the highest that the inference can then allow is that my client has only made an error of judgment, and that therefore its subjective intention gathered from the objective circumstances cannot amount to bad faith. And we do say that that is a good piece of reasoning. We don't rely upon the judgment, notwithstanding that it is a judgment of my Lord Justice Arnold. It had other merits, and the other merits are that the reasoning we say is correct and applicable. So just having foreshadowed those points, my Lord, may I turn to the meat of my arguments, conscious that you've read my skeleton argument and that I think, having heard my learned friend, I've anticipated much of what he was going to say. This court will, of course, be concerned to ensure that a legitimate challenge to a party's rights is not shut out preemptorily before disclosure or before evidence, particularly so where the nature of that challenge is by necessity often to be the subject of inference. But my lords, I hope will also be astute not to allow a party to put to the great cost and trouble of answering what we say amounts to a mere assertion without more, or indeed to allow a party to fill in the absence of a solid basis for its allegation with appeals to the magic formulation inference. And that point is one that I'll return to. As the learned judge said, this is a case by my learned friend that relies upon an edifice of inferences. One must step from inference to inference to inference to get to the allegation of bad faith. And we say in each case the step is not available.
Two points, if I may, Mr. Bradford. First of all, isn't a pleading all about making assertions? That's what it does.
Indeed, my lord, indeed.
So to say this is mere assertion doesn't really get you anywhere, does it? That's what a pleading does.
I think the answer to that, my lord, is that there is a level of assertion to be considered. Consider the most extreme example, that my learned friend's pleading simply consisted of the phrase, your registration is in bad faith. We say that plainly wouldn't be sufficient, although it makes clear what the nature of the allegation is. And why is it not sufficient? Because we say the basis for that allegation is not set out. That's why we draw the distinction between the matters that they say lead to the particular kind of allegation that they rely upon. And in the same way, my lords, I think there's a related point, which is about the presumption of innocence, the debate that happened and on which the learned judge came to the conclusion you don't need to plead facts that are only consistent with bad faith. It's sufficient that you can plead facts that are also consistent with good faith. There has to be a limit to that too, because, for example, if one is to plead a fact that is relevant to both good and bad faith, namely that you have applied for a mark, which is plainly a fact and plainly potentially consistent with both, that alone too would not be sufficient. That's why we say that the key is to look at the combination of objective circumstances that they raised, and that in fact is to be found in all of the judgments we say as a consistent theme. It's in very clearly, we say, paragraph 43 of the Hasbro judgment to which you were just taken, and if you have it before you, we say, excuse me, not 43, 44, we say that summarises the position, but I'd like to take you to another UK judgment as well. Let me, if you have Hasbro, which is at tab 6, and at page 85, and I know, my lords, my lady, you've looked at this because you were just discussing it with my learned friend. 42 is the paragraph that identifies the presumption of good faith. At 44, it's then explained the proprietor of the trademark at issue is best placed to provide the EU IPO with information regarding his or her intentions at the time of applying for registration of that mark, and to provide it with evidence capable of convincing it that in spite of the existence of objective circumstances. And those, we say, are the crucial words. There have to be objective circumstances that require us to come forward and meet the challenge. And it is that the learned judge at first instance was addressing herself to. We say in great detail and with great care. My learned friend hasn't explained that there was any oversight, any taking into account of matters she shouldn't, or not taking into account matters that she should. He simply re-argues what he said below, and we say that's not good enough. 95 and 96 of her judgment, which I have quoted at paragraph 20 of my skeleton, we say do precisely that. They consider if there are objective circumstances that demand that I come before you, put myself to the cost and the expense of establishing what my intentions were, we say not. My lord, I think you said there were two matters you wanted to raise. Was that just
Yes,
the first?
you were complaining about inferences, but unless the proprietor who is alleged to have made an application in bad faith confesses, it's all going to be.
Absolutely, and indeed the Advocate General in Lynch, you see at paragraph 58, says quite rightly that it will often, 9 times out of 10, be only a question of inferences. I say in my skeleton argument, in my written submissions, our complaint is not that it is an inference that you rely upon. That is plainly a possibility, certainly at this stage, before there is evidence of disclosure. What we say is, please look at the particular inferences. That's why I ask once again, we say the judge correctly did. Do not be lured by my learned friend's suggestion that there is this nature of bad faith, a point on which we have no disagreement. We don't disagree that a defensive mark is something that could be bad faith. But we ask you, in this case, what matters do they plead that demand that there must be a trial over that issue? That is the point of difference between us. And we say the learned judge focused on that question. And she looked at the specific issues that they raised. And what she saw, and this is the point that I will need to go through in a bit of detail, is that, first of all, they boil down to the same point. The mark with text and the wordless mark are obviously related. And secondly, all of the points that they rely on as allowing an inference of bad faith are in fact matters that, in terms, the authorities say cannot in and of themselves indicate bad faith. And so that's the problem. They haven't identified the objective circumstances. That's why we say the learned judge was so keen, repeatedly, to say to my learned friend, is there anything else? Do you want to amend, to introduce any of the details? That's why she herself went out and investigated on this question of evergreening, whether there were anything in the details of that allegation that would have made the difference. And of course there weren't. But my learned friend hadn't pleaded them anyway. And the reason he hadn't pleaded them is because the problem is fundamental to the allegation. Reapplication is not in and of itself bad faith. It says that repeatedly in the authority. You need something more, and they haven't given us anything more. We say for the good reason that the allegation is fundamentally flawed. But that would be a point further down. I say I don't need to answer it. So, my lords, my lady, I wanted to draw your attention to one other judgment, which is the Jaguar Land Rover case, which both Lord Justice Floyd, or Christopher Floyd, refers to, and of course the learned judge refers to. It was a judgment of Lord Justice Newgee, or Newgee as he then was, and it's to be found at page 156 behind tab 8 in the Joint Authorities bundle. And the particular paragraph, it's not the detail of the case so much as the setting out of the test that I draw to your attention, and that's to be found on page 156 in paragraph 46. And again, one sees the clear influence of my Lord Justice Arnold on the case law in this, but perhaps for those of you who didn't write the judgments, might I ask you to read paragraph 46, please.
Yeah, well, the case law's moved on a bit since we.
It has, and indeed
That was 20 years ago.
Indeed, but being referred to in a case from only 4 years ago. And certainly one distinction is that here, the judge is saying inference alone is never going to be possible. I fully accept that
That goes too far.
That goes far too far. But what is interesting, my lords, my ladies, is to see the very strenuous requirements on such an allegation, and that it isn't simply enough to make the allegation and then wait to see if anything comes out to support it. You have to give a reason for the court to investigate it that goes beyond the presumption of innocence. And we say those are a requirement for objective circumstances that, in spite of them, you therefore have to show that you had a bona fide intention.
But if we're talking about pleading, which is, I think, what we really are talking about.
Yes.
Let us suppose that somebody is alleging a fraudulent misrepresentation. It would normally be enough, wouldn't it, to say, you told me A, and you knew it wasn't true, or you didn't care whether it was true or false. You wouldn't have to go into why you say that, would you?
Quite possibly not in the context of a fraudulent misrepresentation. But here the issue is the intention of the party at the time that they applied for the trademark.
Yes, exactly.
And I think that may be the difference, because here the inference is supposed to tell you something about the intention at the time of the application for the trademark. We say that the matters of fact that they point to don't permit that inference of bad faith. They don't even come close. They don't even permit the starting inference, which is that there was no intention to use. There's then the secondary inference, and the reason there was no intention to use.
I don't understand this, because the two basic facts relied upon are actually common ground. Fact number one, the wordless mark has never been used. You say, in fact, you say that as a matter of law, use of the word mark with the text equates to use of the word mark, and or in the alternative, it's a variant which falls within section 46, subsection 2. But there is no disputing the fact that the wordless mark on its own has never actually been used.
In the UK, so.
In the UK. Fact number two, you admit that the purpose in applying for the wordless mark was to obtain a wider scope of protection. You say that's perfectly legitimate, and you're entitled to do it.
Yes.
But once you have those two facts, why is it not possible to draw the inference that your intention, although you believed it to be legitimate, was in fact objectively illegitimate because it's an abuse of the trademark system?
The answer we say, first of all, I think, my lord, that in fact there are further facts that were common ground and which my learned friend would add to that matrix.
Indeed he does, but
He
why
would
are the
say-
two that I've stated not sufficient?
Indeed. Well, those are ultimately where they boil down to. As I say, all the other points really point back to that fact. The answer we say is that the first point is something that we are not only allowed to do, but which the legislation expressly contemplates we will want to do. And the reason we will want to do it is because we understand that our branding has changed over time. So to point to the fact that there is that overlap doesn't allow any inference about the intention at the time. The second point, as I understand it, which is the fact of later reapplications, they have their own justification. But reapplication, again, itself is not indicative of bad faith. So we don't understand why two matters which are themselves both contemplated and indeed expressly allowed for in the legislation can indicate that we had a bad faith intention at the time that we applied for. It may be that in the argument over whether or not the use that we seek to rely on is use of the wordless mark, we fail on the Specsavers argument, the legal argument. But we say that would simply establish that we have made an error of judgment as to the kind of use you could rely upon. The fact that such use is permitted is, we say, enough to mean that that inference of bad faith intention isn't available to you. I put it rather well in one of my notes. So let me try and put it now. Yes. So in fact, this is the point at 47.1. It's never been used in the form on the register. And they say that's an unusual feature of this case because we rely on that medium of use. And that fact, that admitted fact, is something they say is something unusual that needs justification. And although that we say that is their strongest point, the strongest link for the inference, it's nonetheless a bad one, because it commits the formal fallacy of begging the question by assuming its conclusion. Either such use is acceptable, or it isn't. If it is acceptable, then it's plainly fine to rely on it, and pointing to the fact that we rely on it doesn't indicate any bad faith intention. The fact that one relies on an acceptable form of use cannot allow the inference that one didn't intend to use the mark for its essential function, which is the nature of the abuse of law that the cases repeatedly identify.
But you admit you've never used it.
In the form was on the register. Yes,
Yeah.
I do.
First registered 1995, so we're now 27 years later.
Yep.
Never used, not in dispute.
You mean never used in the form on the register?
In the form of the register.
Indeed, but that's my point, my lord. In that distinction, we say lies everything. Because not to use it in the form on the register is perfectly permissible, provided that it is in the form that doesn't alter the distinctive character and or the 46.2 point. And that's why I say it's a problem that assumes its conclusion. If that's legitimate use, and the Act contemplates it, and the law clearly accommodates it, how can pointing to legitimate use allow an inference of bad faith, let alone an intention not to use? We say it can't. That's, I think, where the point
that's being made is that you're not really using the wordless mark in a modified form. What you're really using is the mark with the word.
Yes, that is the argument.
And therefore, there was no need to have the wordless mark. It doesn't do anything which you couldn't already do.
But that is their argument on why we have not used it, as to which there is a dispute. The kind of use that we rely on is contemplated by the legal structure. It's acceptable use if we're right that it's use that doesn't alter the distinctive character.
Well, that may or may not be so.
Indeed.
But the point that's being made against you is that if you were able to use something approximating to the wordless mark because you had registered the mark with the word, then there is no commercial rationale for registering the wordless mark except to enlarge the scope of your protection and to use the wordless mark defensively against a sign which uses those colours but now bears the word club card, club prices on it.
Indeed, my lord. And we don't shy away from the idea that this mark is intended to provide us with a protection in that scenario. Because what we have recognised in 1995 is that this is something that is identifying our goods and services, and we therefore seek protection for it. And we're entitled to do that. The law contemplates that we can do it. If, therefore, the law allows you to do that, it's very odd to point to something that the law says is acceptable use and say that's a marker of bad faith or allows an inference of bad faith. More than that, they go further. They say it shows you that there's no intention to use. But we say we are using it. There's a dispute over whether the form of use we're making it is use in a form that doesn't alter the distinctive character. But the fact that that's arguable shows that the worst case scenario here is, as we said earlier, by reference to the McBride point, an error of judgment on our part. The fundamental inference that they seek to raise, non-use, solely there to sit squatting on the register and frightening people off like a scarecrow, it's not available to them because the matter that they point to is something that we say is lawful use contemplated by the Act. This is the point that the judge references both at 102, where she references the McBride point, but also in her judgment, I think, at 85, because there she talks about precisely that question of overlapping.
Paragraph 85.
Yes, sorry, my lord, let me get it up. So tab 3.
Yeah.
I hope I've given the correct reference. I'm doing it from memory.
Yes.
It should have the reference at the end to 46.2. It does, yes.
Yes.
And that's why we say when you look at the actual fact that they point to, which is, as my Lord Justice Arnold points out, not a matter of dispute, we say that it doesn't allow the further inferences that they seek to draw from.
So why did the claims for bad faith in Kinder and Target Ventures succeed? Because on your argument, they should have failed.
But, my lord, I don't know the specifics of the facts in that case.
You do, because they're set out in the judgment.
Well, my lord, I don't know why it was that they were persuaded in that case. We say that in this case, the answer is that the circumstances that are pointed to at this stage were not sufficient. My lord, I wanted to come up with an analogy. Imagine that the use dispute is of a different kind. So now over whether the use falls within a particular specification of goods, or justifies the retention of a particular level of independent subcategory of goods. Realise as I'm saying this that I'm doing that thing that trademark lawyers do where they assume everyone's as excited about trademark law as they are. They know the nuances, but I know this panel in particular is well familiar with it. But there can be issues, as arose in the Skykit case, to whether or not you're entitled to retain the specification of the goods by reference to the use you've made. Now, we say the nature of that dispute is akin to the one in the present case. There's no issue over whether there has been the use relied on. It's common ground that we have made use of the mark with text. The only question is over its correct categorization. And where there's such a legitimate argument, i.e. the position is not strikeable, but has a realistic possibility of success, you can't suggest that the existence of that argument allows an inference that the application was made knowing that the argument was untenable, and yet that's what my learned friend is trying to do. I raise the analogy to show there's nothing special about the nature of the argument in this case that means it uniquely justifies an inference of bad faith, but other arguments of non-use do not.
But it's a bit different from the normal kind of case, isn't it? Suppose that what you had registered was the mark with the text, and in fact you had only ever used the wordless mark.
Yes.
You were then wanting to rely upon section 46 subsection 2.
Yes.
Now that would be a conventional sort of dispute, and the court would have to take a view as to whether that was sufficient or not. But there would be no question of you in some way enlarging your rights, because the registration you were seeking to support would still have the words within it. And therefore, you would still have to get over that hurdle when it came to infringement. Here, the whole point of the exercise is to enable you to bring a claim for infringement when the text is actually quite different, as my Lord Justice Lewison pointed out to you. Therefore, the whole point of the registration is to enlarge your rights, and you don't admit that. You don't dispute that. You admit it. Therefore, the question is that legitimate?
Yes, my Lord.
And if the law is that that's not legitimate, then why is that not a perfectly good claim of bad faith?
Well, my Lord, the difficulty I have with that is I'm allowed to register a mark which represents something that I consider to be an identification of origin.
Yes, but you see,
and indeed,
you say that Tesco's case assumes the conclusion that they seek to prove, but your argument does the same. Both of you start from the proposition that the activity in question is either legitimate or illegitimate, depending on where you stand in the court.
But there is a difference, my Lord, which is that I start with a presumption of innocence and my learned friend does not.
Indeed
and that,
so.
I think, is a very material difference, my Lord, to which attention must be paid, because it is the reason why one must only be troubled by these allegations in circumstances where objective circumstances, beyond simply the allegation this is bad faith, have been raised. And that's what we say the learned judge at first instance correctly identified. What are the circumstances to say that this is something more than just my client recognising that here we have something that the public, its consumers, recognise as indicating its origins and services? And they point to the fact that we haven't, that there is the mark with text, and it came in registration terms before in time, and the fact that we rely upon the uses of the mark with text to justify the uses of the wordless mark. And then they have their point about reapplications, to which I'll come. But we say all of those are themselves not permissible, do not permit, I should say, in and of themselves an inference of bad faith, because you are allowed to register a mark that broadens your protection, and indeed Lint contemplates you may do so once you realise that your reputation is of a particular kind. Indeed, it's not just Lint that says that. The point appears in other cases, such as Rintish. I'll take you to that as well. But it must be a matter of common sense once you've realised that there is an identifier that you want to protect because the public use it to identify your goods and services. My lords, my lady, you know in this case we have a survey that we say shows exactly that.
If we are, as the court suggested in Hasbro, within the territory of abuse of rights, the fact that you comply with the formal requirements of the legislation is not necessarily an answer.
Well, that's correct, my lord. But the question is, are we in that territory? And the answer to, or the issue that raises is, what does my learned friend point to that tells you we are in that territory? He points to two matters that are in and of themselves not indicative of an abuse of law. First of all, the overlap of the marks, Secondly, the fact of reapplication by later marks. We say that's why he's not getting to the point where you need to concern yourself. I don't need to look to see if there are any documents that explain what my intention was at the time. He just hasn't overcome the burden that's on him at the outset. My Lord Justice Arnold said that facts are admitted. The first one, obviously, is this question of overlap. I just wanted to make sure I've been through all of them, because I agree that the matters that my learned friend points to aren't, it's not a dispute over whether they did or didn't happen, but what they can tell you about our intention at the time of the application, and the first of them was this overlap of the marks. The second is the chronology, in the sense that the mark with text was devised, they say, in or about 1987, but the wordless mark not registered until 1995. That's paragraph 47(2) of their pleading. And that's said to allow an inference that the wordless mark wasn't used or intended for use. We say, in fact, that pleading is incoherent, because the chronological matters that they point to are unconnected. There's a missing or suppressed premise, and it's the one that they gave in argument to the judge, namely, it's not just that the mark with text was devised in 1987, but also that it was registered in or about that time. And the inference from that chronology is then said to be, there was no understanding on my client's part that the wordless mark was being used, because if it were so, why didn't it register it contemporaneously with the mark with text? Well, we have a number of points in answer to that. First, we say there's no necessary connection between the prior registration of another mark and the timing of the registration of this mark. In particular, we say it tells you nothing about use of a later registered mark, which is the inference they seek to make. My lords, my lady, you understand the difference I'm pointing to is between use and registration. They try to point to an issue on registration as if it told you something about use. Second, the inference alleged here is that we had not used the wordless mark prior to 1995, so didn't seek to register it. But whether the chronology permits the drawing of that inference, we say must of course allow for the full picture. Our mere knowledge of the course of the law and of the nature of the registrations themselves, we say, shows why that inference is unavailable to them. And we offer therefore 2 points of context, not matters we say of law, but matters of judicial knowledge. The first is that the chronology ignores the significant change in the law that occurred in October 1994 with the introduction of the new Trademark Act. We say that's significant because the new Trademark Act offered significantly greater scope for the registration of marks to encompass all those capable of graphical representation. In particular, where the old law emphasised word marks, the new law made it significantly easier to register purely graphic marks. It was possible under the old law, but you had to go through more hoops. Now that would be a perfect...
I'm sorry, I don't begin to understand that. In what respect, you say, it was easier to register a device mark under the 1994 than under the 1938 Act?
Because under the 1938 Act, as I understand it, obviously not an area I practiced in, my law will know it better, my understanding is that in order to register a purely graphic mark, you also had to establish that it was distinctive at the time of use. You might well back away from it.
No, many device marks were registered without them being
certainly
used.
not suggesting it was impossible, my lord. I'm simply saying that there was a difference, which is that under the EU harmonised law, the only condition was whether or not it was capable of graphic representation. That was not the case under the 1938 Act. There's another point that we make, my lord, of context. We rely on 2 registrations for the basis of infringement. The ones I'm calling the 658 marks, those are the 3 1995 marks, and the 343, which is the 2005 mark. The 343 is registered for services only, and that was applied for in November 2005, which was shortly after the Court of Justice's decision in Practica Bow, case C418 of 02. And that was a case, my lords, my lady, may be familiar with. I know that Lord Justice Arnold is, because he argued one of the first appeals from the IPO on the basis of that case before Sir Christopher Floyd. That was the case that made possible, or made it clear that it was possible, that you could apply for retail services. And if one looks at the registration for that mark, you'll see that it is primarily, not exclusively, but primarily in relation to Class 35. I want to return to that point, therefore, when I talk about evergreen.
So I'm a bit lost at the moment, Mr. Brandreth.
Yeah.
You're raising some interesting questions about changes in the law over time.
Yeah.
These may be germane, but what have they got to do with the issue before us? Because to the extent that it is your client's case that their actions are explained by changes in the law at points in time, that is something that is neither pleaded nor in evidence.
Indeed. What I'm saying, my lord, is, and this is very much a subsidiary point, you already have my main point, that if my learned friend comes before the court and says the only inference that's available is that you haven't used it, that's the chronology explanation, he ought to be able to explain that that inference arises in the full context. And he doesn't even address those issues of context. But, my lord, it's not a point I rely on, indeed, it wasn't a point I made to the judge at first instance. I raise it to illustrate, once again, why the chronology point really just boils down to you've got the mark with text first. It's the same point. You've got an overlap. But I did also, in this context, want to raise a point I did make below, and which I make again, which is the chocolate and fabric and lint point that's repeated by, or summarised by Lord Justice Floyd in Skykick at paragraph 6712, that the reputation of the mark may justify wider legal protection. Now here we know that Tesco admits that the mark with text has a reputation. That's paragraph 10, one of their defence. And we say, for that reason alone, the chronology point alone, the mere reference to the chronology, doesn't permit an inference of non-use, or more specifically of knowing non-use. And again, it comes back to that fundamental point. There's a difference between using something and choosing to register it. And what Lint is recognising is you may come to a point where you decide, oh, I want to get a registered protection for this later in time. And you do that because you realise that the use you've made has resulted in a reputation for that specific aspect. The problem is that the chronology doesn't allow any inference at all, though they purport to say that it does. The third point, my lord, is actually one that we've talked about already, which is the broadening of protection issue, which is 47.3 of their skeleton argument. As I think I've already said, the points run together with what was said at 47.1 and 47.2, because now we have what is said to be the motivation for the wordless mark in a world in which it's said that the wordless mark is only used with the word Lidl over it. And for that reason we say the matters I've already referenced under 47.1 and 47.2 by here also. But my main answer to this point is the one I've already given. It's not only permitted, but specifically contemplated. The judge sets out the points at paragraph 85 of the judgment. It's in that context I'm supposed to have made a confession. I've addressed that in my written submissions at 41 to 46, and I won't repeat what's said there. I did want to add one reference from the authorities at this stage, which is the Rintish Proti Plus, I should say, case, which is one of my learned friends' authorities. It's at tab 3 in the Joint Authorities bundle. And it's paragraphs 20 to 24 that I wanted to draw your Lordship's attention to. And again, the reason I skip straight to these paragraphs is that these are explanations of the law rather than applications of the law to the specific facts in this case. Perhaps I might ask you to read from paragraph 20, well, since my learned friend has marked it, down to the end of paragraph 24. Yeah.
I'm a bit puzzled as to why you say that this passage supports you as opposed to being against you. Why is this not supportive of the proposition that I was putting to you earlier. Look at paragraph 22. The different form in which that mark is used should not of itself be registered as a trademark. And so the registration of new forms of a trademark is possible to anticipate changes that occur and adapt it to the realities of a changing market. So the whole point of all of this is that you can be protected in circumstances where you are evolving your use over time, and you may not have registered the current form in which you're using, or even if you have, you want to keep alive your old form of registration. Why is that an answer to the point that if your purpose is not to protect something that is evolving over time, but to protect something that you never use and never intend to use with a view to widening your scope of protection, that is illegitimate?
Well, the answer is again about inference, my lord, because what this passage shows, like Lynch shows, is that the law expressly contemplates these are the kinds of steps you might want to take. And my learned friend comes to you and says, from a step that the law contemplates, indeed, as we say in paragraph 22, echoing Lynch, acknowledges you'll probably want to do because the situation develops over time, you can infer that there was bad faith. Now, what my lord, I think, said to me is, why can't you have bad faith of the kind where what you're doing is illegitimately trying to broaden protection by registering a defensive mark? Again, as I say, in the abstract, plainly that could be a form of bad faith. What I'm urging upon your lordships, my lady, is to ask, well, why do they say that's happened here? And the point that the fact they point to is something that's just run-of-the-mill. We registered another mark later on that there's overlap. And British expressly contemplates it should be allowed because that's how things develop. But from that, we say, hoinking on their bootstraps, they say, well, you should infer that we never intended to use. And the reason we never intended to use is because we only ever intended it to act as a defensive mark squatting on the register. You say, those inferences can't follow from something that is legitimate. And Rintish is another example of the law expressly contemplating us doing what we're doing. You need something more, some further objective circumstances that allow that to happen. When we look at Hasbro,
suppose I mean, I don't know whether this is admitted, that you accept you haven't used the word mark for
in the form as registered.
Over 25 years. Yeah. Do you accept you have no intention of using the word as mark or not?
Quite the reverse,
Right.
my lord. If you mean,
Right.
so to be specific, word as mark in the form as registered. Not only do we say we have used it, but not in the UK.
Right. But just sticking with that, no intention to use, no intention of future use. Why could you not say, well, you haven't used it for 25 years, and we infer from that that you never intend to use it? Why is that not a legitimate inference?
But that wouldn't be a problem, my lord, because I'm allowed to use it in the form that I am using it, namely via the mark with text. So when you say to me, not use it, what I think, if I may rephrase it without wishing to speak over my lord, for 25 years I say I have used it in one form. And a form I'm allowed to use it in that the trademark law recognises and is permissible. You ask me, well, do you only intend to carry on using it in that form? And I might well answer, I mean, I don't know what my client's intentions are in terms of broadening its use format, but it might say, yes, we're only going to carry on using it in that form. That still wouldn't tell you anything about our intention at the time we registered it, other than that we intended to use it in a form that the law contemplates is permissible. That's the fundamental problem. It's why the existence of the argument over whether or not that's good enough use doesn't help them. And to answer my Lord Justice Arnold's point, that's why I say something like Rintish is helpful to me, not because it means that you can't have bad faith of the kind that my Lord correctly identifies might well be bad faith, but because it goes to the question of what inferences do they say allow you to say it's happening in this case. And they point to something that's no more than what the law contemplates you'll do anyway as a matter of natural expansion of your trademarks. And that's the point in Lint and so on and so forth. My Lord, their final pleaded point in paragraph 47 is subparagraph 4. And actually this feeds back to the point I made right at the beginning in answer, in addressing my Lord Justice Lewison's question about the pleadings and the summary judgment. You'll see, as I say, my skeleton at paragraph 32C.
But
2C, my lady. It's page 234 of the core bundle, behind tab 13.
Yeah.
You see, basically, I say 47.4 isn't a new point. It's not a separate matter to be considered. It is the allegation that they say is supported by the other points. And that's what I say is the distinction that I draw in answer to my Lord's query to my learned friend. My Lord's evergreening. I don't anticipate being finished in the next 5 minutes, my Lord, but I'll go as far as I can. Right. This is paragraph 48, and the starting point in my submission is that this is intended to be supportive of their main pleading. It's not a separate point. It has now morphed into becoming one, but as you see from the pleading, it's intended to support by being an indication, they say, that we were worried about non-use. That's their primary allegation. Now, my lords have seen this, so maybe I don't need to take you to the specific wording, but it is their pleading that there is no other reason to explain these further applications except the one that they put before you, namely that we were worried that we hadn't made use and therefore needed to reapply to avoid losing the benefit of the grace period. You see that most clearly at 48.2.
Yeah.
There was no, my lord has. Now, we say a number of points here. The first and the most important is that the mere fact of reapplication is not indicative of bad faith. At first instance, my lord, that was conceded by my learned friend, and we say it was a concession rightly made. The reference I would like to give you on that is from the Hasbro case, and it helps to take it up, partly because it also feeds into this overarching question about objective circumstances. So Hasbro, my lords, my lady, is in the Joint Authorities bundle behind tab 6, and the reference is paragraph 70, to which I think you have already been taken.
70, did you say?
70, it's page 88 in the bundle.
Yeah.
Two points. The first is that it's clear on its face that mere reapplication in and of itself is not indicative of bad faith. But second, I must accept that you could couple it with other matters, that's what they say at the end of the paragraph, to indicate that there was something that meant that on this occasion the reapplication was indicative of bad faith. The question, therefore, is there anything? And it's in that light, of course, that the judge at first instance was so keen to probe with my learned friend both the details and the question of whether there was anything to be added by way of pleading. In fact, it is simply the reapplication that they point to. But we say that's not good enough, and Hasbro is clear authority to that effect. In fact, we go further. We say it's not just that there isn't a contrary provision, there's a positive provision acknowledging reapplication where that is of an EU mark relative to a UK mark, and that's in the form of seniority, which was Article 35, now Article 39 of the regulation. And I put that in tab 1 of the Joint Authorities bundle. The point of seniority of a national trademark is that one can say when registering an EU mark sorry, I'll wait for my lords and my ladies to take
Sorry, which article are we looking at?
So it's Article 39, it's at the bottom
Yep.
of page 5. And you see provision 1, the proprietor of an earlier trademark registered in a member state, including a trademark registered in the Benelux countries or registered under international arrangements having effect in a member state, who applies for an identical trademark for registration as an EU trademark for goods or services which are identical with or contained within those for which the earlier trademark has been registered, may claim for the EU trademark the seniority of the earlier trademark in respect of the member state in or for which it is registered. Now, if one turns over the page then to subparagraph 4, one sees that the seniority claimed for the EU trademark shall lapse where the earlier trademark, so that would be the national trademark, the seniority of which is claimed, is declared to be invalid or revoked. So you only get the benefit of seniority for your EU mark.
Yeah, but it has to be explained what the purpose of seniority is, which is spelled out in paragraph 3.
Indeed, my lord.
Which is where you surrender the earlier trademark or allow it to lapse, then you will deem to continue to have the same rights as if the earlier trademark had continued to be registered. So
Indeed.
This is all about the interface between the pre-existing national systems and the new EU system, originally the community system, and ensuring that proprietors who transition from one to the other don't lose their rights.
Indeed, and my lord, of course, knows these provisions better than anyone here. Article 39 is reflected, I say, in recital 8, to which I was also going to take you, which my lord is ahead of me, because I say recital 8 is a reflection of the very point that my lord is making, namely that the regulation contemplates an interrelationship between national and EU marks. Could I ask you to read recital 8? I'm sure my lord will just sign already knows it.
Once we've read it, would that be a convenient moment to break?
It would, my lord.
How much longer are we going to be?
Not very long, like my learned friend. I think evergreening is the last point to be addressed. So, very briefly after the break.
All right. 2 o'clock.